Hi there, I'm Seb Maley from Qdos, and in this video we're going to be taking a look at the world beyond IR35. Now that particular legislation has been reformed and people could probably do with a bit of a break from hearing about it. IR35 was designed to target people who work through, or now those who engage people who work through, limited companies or personal service companies. This was because prior to April 2000, companies could engage workers who were using a limited company without any employment or tax status risk. And the government felt that this was being used extensively as a loophole. But those using PSCs only make up a small proportion of flexible workers in the UK, a population of people which has grown significantly in numbers over the last 10 years or so. IR35 has naturally grabbed the headlines over the last few years, but the issue of tax status goes much further than this, and we have found that there is a distinct lack of awareness and education, which could leave businesses with some very unpleasant surprises. One thing we have heard a lot about is status for employment rights. Everyone will have read about Uber drivers successfully securing worker status, which from an employment law perspective is halfway between being self-employed and an employee. Uber wasn't the first. There's a long list of similar cases before it, and it certainly won't be the last. What we don't hear much about is the tax side of things. Because of the way the system operates, there is no direct correlation between employment law and tax. Cases are heard at different tribunals, and a ruling or decision in one won't have an automatic impact on the other. As of the end of last year, there were 4.3 million self-employed people in the UK. That's less than there was a year before because of COVID-19, but you would expect numbers to start to grow again as we pull out of the pandemic. A chunk of those people will be small businesses who provide goods or services to multiple clients. In those cases, status isn't going to be a consideration. But a lot of self-employed people will have longer engagements with the client where they're providing services, labour or advice, and this is where tax status and what HMRC call false self-employment can start to present a real risk. For instance, of that 4.3 million, over 800,000 work in construction. In the construction sector, it's very common for self-employed subcontractors to be working for a main contractor. For instance, a bricklayer working for a building firm. Tax in construction is partially self-regulated because of the Construction Industry Scheme, or CIS, which means tax is deducted at source by the party engaging the subcontractor. But this only really deals with the worker's income tax and not the tax a company would pay if the worker was an employee. This represents quite a substantial amount, and we have found that there is a dangerous misconception of people thinking that by remaining compliant with CIS, workers and engagers are also dealing with status. This isn't the case though, and for these firms, there's a very real risk that HMRC will challenge the validity of the status of these subcontractors. In fact, I think the risk has increased substantially because of IR35. With the full self-employment of sole traders, the responsibility and liability has always rested with the would-be employer. The same is now the case with IR35, which means that HMRC can deal with compliance activity essentially in the same way. It's obvious that they will put resources into policing status over the next few years, and engagers of flexible workers of all types need to be aware and prepared. Because we think it's such a concern, we'll release some more videos looking at the specifics of the various rules and legislations at play here. But if you have any specific questions, please do get in touch. Thanks for watching, and we'll see you again soon.